Welcome to today's Triple Z. The Triple Z podcast is a daily recording that you can use to help you fall asleep each night. Just turn down the volume, lay back and enjoy as you fall asleep. Today we are reading congressional bills from the 117th Congress of the United States of America. We will be reading Part 2 of the House Resolution Number 1 for the People Act of 2021, Contributing Agency Assistance and Registration. In general, in accordance with this part, each contributing agency in a state shall assist the state's chief election official in registering to vote all eligible individuals served by that agency. B. Requirements for contributing agencies. 1. Instructions on automatic registration. With each application for service or assistance, and with each related recertification, renewal, or change of address, or, in the case of an institution of higher education, with each registration of a student for enrollment in a course of study. Each contributing agency that in the normal course of its operations requests individuals to affirm United States citizenship either directly or as part of the overall application for service or assistance shall inform each such individual who is a citizen of the United States of the following. Unless that individual declines to register to vote, or is found ineligible to vote, the individual will be registered to vote or, if applicable, the individual's registration will be updated. B. The substantive qualifications of an elector in the state as listed in the Male Voter Registration Application Form for elections for federal office prescribed pursuant to Section 9 of the National Voter Registration Act of 1993. The consequences of false registration, and the individual should decline to register if the individual does not meet all those qualifications. C. In the case of a state in which affiliation or enrollment with a political party is required in order to participate in an election to select the party's candidate in an election for federal office. The requirement that the individual must affiliate or enroll with a political party in order to participate in such an election. D. Voter registration is voluntary, and neither registering nor declining to register to vote will in any way affect the availability of services or benefits, nor be used for other purposes. 2. Opportunity to decline registration required. Each contributing agency shall ensure that each application for service or assistance, and each related recertification, renewal, or change of address, or, in the case of an institution of higher education, each registration of a student for enrollment in a course of study, cannot be completed until the individual is given the opportunity to decline to be registered to vote. 3. Information transmittal. Upon the expiration of the 30-day period which begins on the date the contributing agency informs the individual of the information described in paragraph 1, each contributing agency shall electronically transmit to the appropriate state election official, in a format compatible with the statewide voter database maintained under Section 303 of the Help America Vote Act of 2002 to 52 U.S.C. 21083. The following information, unless during such 30-day period the individual declined to be registered to vote, are the individual's given names and surnames. B. The individual's date of birth. C. The individual's residential address. D. Information showing that the individual is a citizen of the United States. E. The date on which information pertaining to that individual was collected or last updated. F. If available, the individual's signature in electronic form. G. Information regarding the individual's affiliation or enrollment with a political party, if the individual provides such information. H. Any additional information listed in the Male Voter Registration Application Form for elections for federal office prescribed pursuant to Section 9 of the National Voter Registration Act of 1993, including any valid driver's license number or the last 4 digits of the individual's social security number, if the individual provided such information. See alternate procedure for certain contributing agencies. With each application for service or assistance, and with each related recertification, renewal, or change of address, any contributing agency that in the normal course of its operations does not request individuals applying for service or assistance to affirm United States citizenship either directly or as part of the overall application for service or assistance shall 1. Complete the requirements of Section 7A6 of the National Voter Registration Act of 1993 to 52 U.S.C. 20506A6. 2. Ensure that each applicant's transaction with the agency cannot be completed until the applicant has indicated whether the applicant wishes to register to vote or declines to register to vote in elections for federal office held in the state. And 3. For each individual who wishes to register to vote, transmit that individual's information in accordance with subsection B3. D. Required availability of automatic registration opportunity with each application for service or assistance. Each contributing agency shall offer each individual, with each application for service or assistance, and with each related recertification, renewal, or change of address, or in the case of an institution of higher education, with each registration of a student for enrollment in a course of study, the opportunity to register to vote as prescribed by this section without regard to whether the individual previously declined a registration opportunity. Contributing agencies. 1. State agencies. In each state, each of the following agencies shall be treated as a contributing agency, each agency in a state that is required by federal law to provide voter registration services, including the State Motor Vehicle Authority and other voter registration agencies under the National Voter Registration Act of 1993. Each agency in a state that administers a program pursuant to Title III of the Social Security Act 42 U.S.C. 501 et sec. Title XIX of the Social Security Act 42 U.S.C. 1396 et sec., or the Patient Protection and Affordable Care Act Public Law 111-148. See each state agency primarily responsible for regulating the private possession of firearms. Each state agency primarily responsible for maintaining identifying information for students enrolled at public secondary schools, including, where applicable, the state agency responsible for maintaining the education data system described in Section 6201E2 of the America Competes Act 20 U.S.C. 9871E2. In the case of a state in which an individual disenfranchised by a criminal conviction may become eligible to vote upon completion of a criminal sentence, or any part thereof, or upon formal restoration of rights, the state agency responsible for administering that sentence, or part thereof, or that restoration of rights, any other agency of the state which is designated by the state as a contributing agency. 2. Federal agencies. In each state, each of the following agencies of the federal government shall be treated as a contributing agency with respect to individuals who are residents of that state except as provided in subparagraph C of the Social Security Administration, the Department of Veterans Affairs, the Defense Manpower Data Center of the Department of Defense, the Employee and Training Administration of the Department of Labor, and the Center for Medicare and Medicaid Services of the Department of Health and Human Services. The Bureau of Citizenship and Immigration Services, but only with respect to individuals who have completed the naturalization process. In the case of an individual who is a resident of a state in which an individual disenfranchised by a criminal conviction under federal law may become eligible to vote upon completion of a criminal sentence or any part thereof, or upon formal restoration of rights, the federal agency responsible for administering that sentence or part thereof without regard to whether the agency is located in the same state in which the individual is a resident, but only with respect to individuals who have completed the criminal sentence or any part thereof. Any other agency of the federal government which the state designates as a contributing agency, but only if the state and the head of the agency determine that the agency collects information sufficient to carry out the responsibilities of a contributing agency under this section. 3. Special rule for institutions of higher education. A special rule. For purposes of this part, each institution of higher education described in subparagraph B shall be treated as a contributing agency in the state in which it is located, except that the institution shall be treated as a contributing agency only in its normal course of operations. The institution requests each student registering for enrollment in a course of study, including enrollment in a program of distance education, as defined in Section 1037 of the Higher Education Act of 1965 to 20 U.S.C. 10,037, to affirm whether or not the student is a United States citizen, and 2. If the institution is treated as a contributing agency in a state pursuant to Clause I, the institution shall serve as a contributing agency only with respect to students, including students enrolled in a program of distance education, as defined in Section 1037 of the Higher Education Act of 1965 to 20 U.S.C. 10,037, who reside in the state. Institutions described. An institution described in this subparagraph is an institution of higher education which has a program participation agreement in effect with the Secretary of Education under Section 487 of the Higher Education Act of 1965 to 20 U.S.C. 1094 and which is located in a state to which Section 4B of the National Voter Registration Act of 1993 to 52 U.S.C. 20503B does not apply. 4. Publication. Not later than 180 days prior to the date of each election for federal office held in the state, the chief state election official shall publish on the public website of the official an updated list of all contributing agencies in that state. 5. Public education. The chief state election official of each state, in collaboration with each contributing agency, shall take appropriate measures to educate the public about voter registration under this section, Section 1014. One-time contributing agency assistance in registration of eligible voters in existing records. An initial transmittal of information for each individual already listed in a contributing agency's records as of the date of enactment of this Act, and for whom the agency has the information listed in Section 1013b3. The agency shall promptly transmit that information to the appropriate state election official in accordance with Section 1013b3 not later than the effective date described in Section 1021a. B. Transition for each individual listed in a contributing agency's records as of the effective date described in Section 1021a but who was not listed in a contributing agency's records as of the date of enactment of this Act, and for whom the agency has the information listed in Section 1013b3. The agency shall promptly transmit that information to the appropriate state election official in accordance with Section 1013b3 not later than 6 months after the effective date described in Section 1021a. Section 1015. Voter protection and security in automatic registration. A protections for errors in registration. An individual shall not be prosecuted under any federal or state law, adversely affected in any civil adjudication concerning immigration status or naturalization, or subject to an allegation in any legal proceeding that the individual is not a citizen of the United States on any of the following grounds. 1. The individual notified an election office of the individual's automatic registration to vote under this part. 2. The individual is not eligible to vote in elections for federal office, but was automatically registered to vote under this part. 3. The individual was automatically registered to vote under this part at an incorrect address. 4. The individual declined the opportunity to register to vote or did not make an affirmation of citizenship, including through automatic registration, under this part. B. Limits on use of automatic registration. The automatic registration of any individual or the fact that an individual declined the opportunity to register to vote or did not make an affirmation of citizenship, including through automatic registration under this part, may not be used evidence against that individual in any state or federal law enforcement proceeding, and an individual's lack of knowledge or willfulness of such registration may be demonstrated by the individual's testimony alone. C. Protection of election integrity. Nothing in subsection S or B may be construed to prohibit or restrict any action under color of law against an individual who 1. Knowingly and willfully makes a false statement to effectuate or perpetuate automatic voter registration by any individual, or 2. Casts a ballot knowingly and willfully in violation of state law or the laws of the United States. D. Contributing agencies' protection of information. Nothing in this part authorizes a contributing agency to collect, retain, transmit, or publicly disclose any of the following. 1. An individual's decision to decline to register to vote or not to register to vote. 2. An individual's decision not to affirm his or her citizenship. 3. Any information that a contributing agency transmits pursuant to Section 1013b3, except in pursuing the agency's ordinary course of business. E. Election officials' protection of information. 1. Public disclosure prohibited. In general, subject to subparagraph B. With respect to any individual for whom any state election official receives information from a contributing agency, the state election officials shall not publicly disclose any of the following. I. The identity of the contributing agency. I. Any information not necessary to voter registration. I. Any voter information otherwise shielded from disclosure under state law or Section 8A of the National Voter Registration Act of 1993 to 52 U.S.C. 20507A. If any portion of the individual's social security number. V. Any portion of the individual's motor vehicle driver's license number. Vi. The individual's signature. Vi. The individual's telephone number. Vi. The individual's email address. A special rule for individuals registered to vote. With respect to any individual for whom any state election official receives information from a contributing agency, and who, on the basis of such information, is registered to vote in the state under this part, the state election officials shall not publicly disclose any of the following. I. The identity of the contributing agency. I. Any information not necessary to voter registration. I. Any voter information otherwise shielded from disclosure under state law or Section 8A of the National Voter Registration Act of 1993 to 52 U.S.C. 20507A. If any portion of the individual's social security number. V. Any portion of the individual's motor vehicle driver's license number. Vi. The individual's signature. 2. Voter record changes. Each state shall maintain for at least 2 years and shall make available for public inspection were available, photocopying at a reasonable cost, including in electronic form and through electronic methods, all records of changes to voter records, including removals, the reasons for removals, and updates. 3. Database management standards. The Director of the National Institute of Standards and Technology shall, after providing the public with notice and the opportunity to comment, establish standards governing the comparison of data for voter registration list maintenance purposes, identifying as part of such standards the specific data elements, the matching rules used, and how a state may use the data to determine and deem that an individual is ineligible under state law to vote in an election, or to deem a record to be a duplicate or outdated. B. Ensure that the standards developed pursuant to this paragraph are uniform and non-discriminatory and are applied in a uniform and non-discriminatory manner. And C. Not later than 45 days after the deadline for public notice and comment, publish the standards developed pursuant to this paragraph on the Director's website and make those standards available in written form upon request. 4. Security policy. The Director of the National Institute of Standards and Technology shall, after providing the public with notice and the opportunity to comment, publish privacy and security standards for voter registration information not later than 45 days after the deadline for public notice and comment. The standards shall require the chief state election official of each state to adopt a policy that shall specify each class of users who shall have authorized access to the computerized statewide voter registration list, specifying for each class the permission and levels of access to be granted, and setting forth other safeguards to protect the privacy, security, and accuracy of the information on the list, and B. Security safeguards to protect personal information transmitted through the information transmittal processes of Section 1013 or Section 1014. The online system used pursuant to Section 1017, any telephone interface, the maintenance of the voter registration database, and any audit procedure to track access to the system. 5. State compliance with national standards. A certification. The Chief Executive Officer of the state shall annually file with the Election Assistance Commission a statement certifying to the Director of the National Institute of Standards and Technology that the state is in compliance with the standard referred to in paragraphs 3 and 4. A state may meet the requirement of the previous sentence by filing with the Commission a statement which reads as follows: hereby certifies that it is in compliance with the standards referred to in paragraphs 3 and 4 of Section 1015E of the Automatic Voter Registration Act of 2021, with the blank to be filled in with the name of the state involved. A publication of policies and procedures. The chief state election official of a state shall publish on the official's website the policy and procedures established under this section, and shall make those policies and procedures available in written form upon public request. See funding dependent on certification. If a state does not timely file the certification required under this paragraph, it shall not receive any payment under this part for the upcoming fiscal year. D. Compliance of states that require changes to state law. In the case of a state that requires state legislation to carry out an activity covered by any certification submitted under this paragraph, for a period of not more than 2 years the state shall be permitted to make the certification notwithstanding that the legislation has not been enacted at the time the certification is submitted, and such state shall submit an additional certification once such legislation is enacted. F. Restrictions on use of information. No person acting under color of law may discriminate against any individual based on or use for any purpose other than voter registration, election administration, or enforcement relating to election crimes, any of the following: 1. Voter registration records. 2. An individual's declination to register to vote or complete an affirmation of citizenship under Section 1013B. 3. An individual's voter registration status. G. Prohibition on the use of voter registration information for commercial purposes. Information collected under this part shall not be used for commercial purposes. Nothing in this subsection may be construed to prohibit the transmission, exchange, or dissemination of information for political purposes, including the support of campaigns for election for federal, state, or local public office or the activities of political committees, including committees of political parties under the Federal Election Campaign Act of 1971, Section 1016. Registration portability and correction. A correcting registration information at polling place. Notwithstanding Section 302A of the Help America Vote Act of 2002 to 52 U.S.C. 21082A. If an individual is registered to vote in elections for federal office held in a state, the appropriate election official at the polling place for any such election, including a location used as a polling place on a date other than the date of the election, shall permit the individual to 1. Update the individual's address for purposes of the records of the election official. 2. Correct any incorrect information relating to the individual, including the individual's name and political party affiliation, in the records of the election official. And 3. Cast a ballot in the election on the basis of the updated address or corrected information, and to have the ballot treated as a regular ballot and not as a provisional ballot under Section 302A of such Act. B. Updates to computerized statewide voter registration lists. If an election official at the polling place receives an updated address or corrected information from an individual under subsection A, the official shall ensure that the address or information is promptly entered into the computerized statewide voter registration list in accordance with Section 303A1 of the Help America Vote Act of 2002 to 52 U.S.C. 21083A1 Section 1017. Payments and grants. In general, the Election Assistance Commission shall make grants to each eligible state to assist the state in implementing the requirements of this part or, in the case of an exempt state, in implementing its existing automatic voter registration program. The eligibility application. A state is eligible to receive a grant under this section if the state submits to the Commission, at such time and in such form as the Commission may require, an application containing 1. A description of the activities the state will carry out with the grant. 2. An assurance that the state shall carry out such activities without partisan bias and without promoting any particular point of view regarding any issue. And 3. Such other information and assurances as the Commission may require. See amount of grant. Priorities. The Commission shall determine the amount of a grant made to an eligible state under this section. In determining the amounts of the grants, the Commission shall give priority to providing funds for those activities which are most likely to accelerate compliance with the requirements of this part or, in the case of an exempt state, which are most likely to enhance the ability of the state to automatically register individuals to vote through its existing automatic voter registration program, including 1. Investments supporting electronic information transfer, including electronic collection and transfer of signatures between contributing agencies and the appropriate state election officials. 2. Updates to online or electronic voter registration systems already operating as of the date of the enactment of this Act. 3. Introduction of online voter registration systems in jurisdictions in which those systems did not previously exist. And 4. Public education on the availability of new methods of registering to vote, updating registration, and correcting registration. D. Authorization of appropriations. 1. Authorization. There are authorized to be appropriated to carry out this section of $500 million for fiscal year 2021, and B. Such sums as may be necessary for each succeeding fiscal year. 2. Continuing availability of funds. Any amounts appropriated pursuant to the authority of this subsection shall remain available without fiscal year limitation until expended. Section 1018. Treatment of exempt states. A waiver of requirements, except as provided in subsection B. This part does not apply with respect to an exempt state. E. Exceptions. The following provisions of this part apply with respect to an exempt state. 1. Section 1016 relating to registration portability and correction. 2. Section 1017 relating to payments and grants. 3. Section 1019E relating to enforcement. 4. Section 1019F relating to relation to other laws. Section 1019. Miscellaneous provisions. Accessibility of registration services. Each contributing agency shall ensure that the services it provides under this part are made available to individuals with disabilities to the same extent as services are made available to all other individuals. B. Transmission through secure third party permitted. Nothing in this part shall be construed to prevent a contributing agency from contracting with a third party to assist the agency in meeting the information transmittal requirements of this part, so long as the data transmittal complies with the applicable requirements of this part, including the privacy and security provisions of Section 1015. See nonpartisan, non-discriminatory provision of services. The services made available by contributing agencies under this part and by the state under Section S 1015 and 1016 shall be made in a manner consistent with paragraphs 4, 5, and 6 degrees Celsius of Section 7A of the National Voter Registration Act of 1993 to 52 U.S.C. 20506A. D. Notices. Each state may send notices under this part via electronic mail if the individual has provided an electronic mail address and consented to electronic mail communications for election-related materials. All notices sent pursuant to this part that require a response must offer the individual notified the opportunity to respond at no cost to the individual. E-Enforcement. Section 11 of the National Voter Registration Act of 1993 to 52 U.S.C. 20,510, relating to civil enforcement, and the availability of private rights of action, shall apply with respect to this part in the same manner as such section applies to such act. F. Relation to other laws, except as provided. Nothing in this part may be construed to authorize or require conduct prohibited under, or to supersede, restrict, or limit the application of any of the following. 1. The Voting Rights Act of 1965 to 52 U.S.C. 10,301 et sec. 2. The Uniformed and Overseas Citizens Absentee Voting Act 52 U.S.C. 20,301 et sec. 3. The National Voter Registration Act of 1993 to 52 U.S.C. 20,501 et sec. 4. The Help America Vote Act of 2002 to 52 U.S.C. 20,901 et sec. Section 1020. Definitions. In this part, the following definitions apply. 1. The term chief state election official means, with respect to a state, the individual designated by the state under Section 10 of the National Voter Registration Act of 1993 to 52 U.S.C. 20,509 to be responsible for coordination of the state's responsibilities under such act. 2. The term commission means the Election Assistance Commission. 3. The term exempt state means a state which, under law which is in effect continuously on and after the date of the enactment of this act, operates an automatic voter registration program under which an individual is automatically registered to vote in elections for federal office in the state if the individual provides the motor vehicle authority of the state, or, in the case of a state in which an individual is automatically registered to vote at the time the individual applies for benefits or services with a permanent dividend fund of the state, provides the appropriate official of such fund with such identifying information as the state may require. 4. The term state means each of the several states and the District of Columbia. Section 1021. Effective date. In general, except as provided in subsection B, this part and the amendments made by this part shall apply with respect to a state beginning January 1, 2023. B. Waiver. Subject to the approval of the Commission. If a state certifies to the Commission that the state will not meet the deadline referred to in subsection A because of extraordinary circumstances and includes in the certification the reasons for the failure to meet the deadline, subsection A shall apply to the state as if the reference in such subsection to January 1, 2023 were a reference to January 1, 2025. Part 3. Same-day voter registration. Section 1031. Same-day registration. In general, Title 3 of the Help America Vote Act of 2002 to 52 U.S.C. 21,081 et sec. is amended, 1. by redesignating Section S-304 and 305 as Section S-305 and 306, and 2. by inserting after Section 303 the following new section, Section 304, Same-Day Registration. In general, 1. Registration. Each state shall permit any eligible individual on the day of a federal election, and on any day when voting, including early voting, is permitted for a federal election, to register to vote in such election at the polling place using a form that meets the requirements under Section 9B of the National Voter Registration Act of 1993, or, if the individual is already registered to vote, to revise any of the individual's voter registration information, and B. to cast a vote in such election. 2. Exception. The requirements under paragraph 1 shall not apply to a state in which, under a state law in effect continuously on and after the date of the enactment of this section, there is no voter registration requirement for individuals in the state with respect to elections for federal office. The eligible individual. For purposes of this section, the term eligible individual means, with respect to any election for federal office, an individual who is otherwise qualified to vote in that election. See effective date. Each state shall be required to comply with the requirements of subsection A for the regularly scheduled general election for federal office occurring in November 2022 and for any subsequent election for federal office. A conforming amendment relating to enforcement. Section 401 of such Act 52 U.S.C. 21,111 is amended by striking Section S-301, 302, and 303 and inserting subtitle of Title 3. See Clerical Amendment. The table of contents of such act is amended, 1. by redesignating the items relating to Section S-304 and 305 as relating to Section S-305 and 306, and 2. by inserting after the item relating to Section 303 the following new item, Section 304, Same-Day Registration. Part 4. Conditions on removal on basis of interstate cross-checks. Section 1041. Conditions on removal of registrants from official list of eligible voters on basis of interstate cross-check. A minimum information required for removal under cross-check. Section 8C2 of the National Voter Registration Act of 1993 to 52 U.S.C. 20507C2 is amended. 1. By redesignating subparagraph B as subparagraph D, and 2. By inserting after subparagraph of the following new subparagraphs. E. To the extent that the program carried out by a state under subparagraph A to systematically remove the names of ineligible voters from the official lists of eligible voters uses information obtained in an interstate cross-check, in addition to any other conditions imposed under this act on the authority of the state to remove the name of the voter from such a list. The state may not remove the name of the voter from such a list unless I. The state obtain the voter's full name including the voter's middle name, if any, and date of birth, and the last 4 digits of the voter's social security number in the interstate cross-check, or 2. The state obtain documentation from the ERIC system that the voter is no longer a resident of the state. See in this paragraph. I. The term interstate cross-check means the transmission of information from an election official in one state to an election official of another state. And 2. The term ERIC system means the system operated by the Electronic Registration Information Center to share voter registration information and voter identification information among participating states. B. Requiring completion of cross-checks not later than 6 months prior to election. Subparagraph of Section 8C2 of such Act 52 U.S.C. 20507C2 is amended by striking not later than 90 days and inserting the following. Not later than 90 days or, in the case of a program in which the state uses interstate cross-checks, not later than 6 months. See conforming amendment. Subparagraph D of Section 8C2 of such Act 52 U.S.C. 20507C2, as redesignated by subsection A1, is amended by striking subparagraph and inserting this paragraph. D. Effective date. The amendments made by this Act shall apply with respect to elections held on or after the expiration of the 6-month period which begins on the date of the enactment of this Act. Part 5. Other initiatives to promote voter registration. Section 1051. Annual reports on voter registration statistics. An annual report, not later than 90 days after the end of each year. Each state shall submit to the Election Assistance Commission and Congress a report containing the following categories of information for the year. 1. The number of individuals who were registered under Part 2. 2. The number of voter registration application forms completed by individuals that were transmitted by motor vehicle authorities in the state pursuant to Section 5D of the National Voter Registration Act of 1993 and voter registration agencies in the state as designated under Section 7 of such act to the chief state election official of the state, broken down by each such authority and agency. 3. The number of such individuals whose voter registration application forms were accepted and who were registered to vote in the state, and the number of such individuals whose forms were rejected and who were not registered to vote in the state, broken down by each such authority and agency. 4. The number of change of address forms and other forms of information indicating that an individual's identifying information has been changed that were transmitted by such motor vehicle authority and voter registration agencies to the chief state election official of the state, broken down by each such authority and agency and the type of form transmitted. 5. The number of individuals on the statewide computerized voter registration list as established and maintained under Section 303 of the Help America Vote Act of 2002 whose voter registration information was revised by the chief state election official as a result of the forms transmitted to the official by such motor vehicle authorities and voter registration agencies, as described in paragraph 3, broken down by each such authority and agency and the type of form transmitted. 6. The number of individuals who requested the chief state election official to revise voter registration information on such list, and the number of individuals whose information was revised as a result of such a request. B. Breakdown of information. In preparing the report under this section, the state shall, for each category of information described in subsection A, include a breakdown by race, ethnicity, age, and gender of the individuals whose information is included in the category, to the extent that information on the race, ethnicity, age, and gender of such individuals is available to the state. See confidentiality of information. In preparing and submitting a report under this section, the chief state election official shall ensure that no information regarding the identification of any individual is revealed. D. State defined. In this section, a state includes the District of Columbia, the Commonwealth of Puerto Rico, the United States Virgin Islands, Guam, American Samoa, and the Commonwealth of the Northern Mariana Islands, but does not include any state in which, under a state law in effect continuously on and after the date of the enactment of this act, There is no voter registration requirement for individuals in the state with respect to elections for federal office. Section 1052. Ensuring pre-election registration deadlines are consistent with timing of legal public holidays. In general, Section 8A1 of the National Voter Registration Act of 1993 to 52 U.S.C. 20507A1 is amended by striking 30 days each place it appears and inserting 28 days. The effective date. The amendment made by subsection A shall apply with respect to elections held in 2022 or any succeeding year. Section 1053. Use of Postal Service hard copy change of address form to remind individuals to update voter registration. In general, not later than 1 year after the date of the enactment of this Act, the Postmaster General shall modify any hard copy change of address form used by the United States Postal Service so that such form contains a reminder that any individual using such form should update the individual's voter registration as a result of any change in address. The application. The requirement in subsection A shall not apply to any electronic version of a change of address form used by the United States Postal Service. Section 1054. Grants to states for activities to encourage involvement of minors in election activities. Grants. 1. In general, the Election Assistance Commission, hereafter in this section referred to as the Commission, shall make grants to eligible states to enable such states to carry out a plan to increase the involvement of individuals under 18 years of age in public election activities in the state. 2. Contents of plans. A state's plan under this subsection shall include methods to promote the use of the pre-registration process implemented under Section 8A of the National Voter Registration Act of 1993 as added by Section 2A. Modifications to the curriculum of secondary schools in the state to promote civic engagement, and C. Such other activities to encourage the involvement of young people in the electoral process as the state considers appropriate. The eligibility. A state is eligible to receive a grant under this section if the state submits to the Commission, at such time and in such form as the Commission may require, an application containing 1. A description of the state's plan under subsection A. 2. A description of the performance measures and targets the state will use to determine its success in carrying out the plan, and 3. Such other information and assurances as the Commission may require. C. Period of grant. Report. 1. Period of grant. A state receiving a grant under this section shall use the funds provided by the grant over a 2-year period agreed to between the state and the Commission. 2. Report. Not later than 6 months after the end of the 2-year period agreed to under paragraph 1. The state shall submit to the Commission a report on the activity the state carried out with the funds provided by the grant, and shall include in the report an analysis of the extent to which the state met the performance measures and targets included in its application under subsection B2. D. State defined. In this section, the term state means each of the several states in the District of Columbia. Authorization of appropriations. There are authorized to be appropriated for grants under this section $25 million to remain available until expended. Part 6. Availability of HAVA requirements payments. Section 1061. Availability of requirements payments under HAVA to cover costs of compliance with new requirements. In general, Section 251B of the Help America Vote Act of 2002 to 52 U.S.C. 21001B is amended. 1. In paragraph 1, by striking as provided in paragraphs 2 and 3, and inserting as otherwise provided in this subsection, and 2. By adding at the end the following new paragraph. For certain voter registration activities, a state may use a requirements payment to carry out any of the requirements of the Voter Registration Modernization Act of 2021, including the requirements of the National Voter Registration Act of 1993 which are imposed pursuant to the amendments made to such act by the Voter Registration Modernization Act of 2021. A conforming amendment. Section 254A1 of such Act 52 U.S.C. 21004A1 is amended by striking Section 251A2 and inserting Section 251B2. See effective date. The amendments made by this section shall apply with respect to fiscal year 2020 and each succeeding fiscal year. Part 7. Prohibiting interference with voter registration. Section 1071. Prohibiting, hindering, interfering with, or preventing voter registration. In general, Chapter 29 of Title 8 United States Code is amended by adding at the end the following new section, Section 612. Hindering, interfering with, or preventing registering to vote. A prohibition. It shall be unlawful for any person, whether acting under color of law or otherwise, to corruptly hinder, interfere with, or prevent another person from registering to vote, or to corruptly hinder, interfere with, or prevent another person from aiding another person in registering to vote. Attempt, Any person who attempts to commit any offense described in subsection A shall be subject to the same penalties as those prescribed for the offense that the person attempted to commit. See penalty. Any person who violates subsection A shall be fined under this title, imprisoned not more than 5 years, or both. B. Clerical amendment. The table of Section S for Chapter 29 of Title 18, United States Code is amended by adding at the end the following new item: 612. Hindering, interfering with, or preventing registering to vote. See effective date. The amendments made by this section shall apply with respect to elections held on or after the date of the enactment of this Act, except that no person may be found to have violated Section 612 of Title 18, United States Code as added by subsection A, on the basis of any act occurring prior to the date of the enactment of this Act. Section 1072. Establishment of best practices. A best practices, not later than 180 days after the date of the enactment of this Act. The Election Assistance Commission shall develop and publish recommendations for best practices for states to use to deter and prevent violations of Section 612 of Title 18, United States Code as added by Section 1071, and Section 12 of the National Voter Registration Act of 1993 to 52 U.S.C. 20,511 relating to the unlawful interference with registering to vote, or voting, or attempting to register to vote or vote, including practices to provide for the posting of relevant information at polling places and voter registration agencies under such act, the training of poll workers and election officials, and relevant educational materials. For purposes of this subsection, the term state includes the District of Columbia, the Commonwealth of Puerto Rico, Guam, American Samoa, the United States Virgin Islands, and the Commonwealth of the Northern Mariana Islands. The inclusion in voter information requirements. Section 302b2 of the Help America Vote Act of 2002 to 52 U.S.C. 21082b2 is amended. 1. By striking, and at the end of subparagraph E. 2. By striking the period at the end of subparagraph F, and inserting, and 3. By adding at the end the following new subparagraph, G. Information relating to the prohibitions of Section 612 of Title 18, United States Code, and Section 12 of the National Voter Registration Act of 1993 to 52 U.S.C. 20,511 relating to the unlawful interference with registering to vote, or voting, or attempting to register to vote or vote, including information on how individuals may report allegations of violations of such prohibitions. Part 8, Voter Registration Efficiency Act, Section 1081. Short title. This part may be cited as the Voter Registration Efficiency Act, Section 1082, requiring applicants for motor vehicle driver's licenses in new state to indicate whether state serves as residence for voter registration purposes, or requirements for applicants for licenses. Section 5D of the National Voter Registration Act of 1993 to 52 U.S.C. 20504D is amended. 1. By striking any change and inserting one any change, and 2. By adding at the end the following new paragraph. 2A. A state motor vehicle authority shall require each individual applying for a motor vehicle driver's license in the state I to indicate whether the individual resides in another state or resided in another state prior to applying for the license. If so, to identify the state involved, and 2. To indicate whether the individual intends for the state to serve as the individual's residence for purposes of registering to vote in elections for federal office. B. If pursuant to subparagraph I, an individual indicates to the state motor vehicle authority that the individual intends for the state to serve as the individual's residence for purposes of registering to vote in elections for federal office, the authority shall notify the motor vehicle authority of the state identified by the individual pursuant to subparagraph AI, who shall notify the chief state election official of such state that the individual no longer intends for that state to serve as the individual's residence for purposes of registering to vote in elections for federal office. The effective date. The amendments made by subsection A shall take effect with respect to elections occurring in 2021 or any succeeding year.